Hello, everybody. How y'all doing out there in America, the land of the free, home of the brave? Um, I just want to get on here and give a little bit of update of what's going on in my life. If anybody cared, uh, hopefully I can help people do the same thing that I'm doing or have done on their own instead of having to depend on um, lawyers and such. If you're not guilty of crimes, um, so that's what I'm fighting for. I'm fighting for my constitutional civil rights. Um, I don't know what's worth for y'all, but it's worth everything for me. Um, I'm in a process of litigation with 17 people. Um, I probably would like to do more, but I think that's enough to get my point across. Is it I was wrong, and by law enforcements and agencies, and nobody cared about me and my well-being and my everything, uh, my life as a human being, as a free person, you know. Um, but anyway, I want to come on here and just read stuff and tell people about what I'm doing and where I'm at in my lawsuit. Uh, but before, I like to read an article about the U.S. color of law, 18 U.S. Code 241, 242, conspiracy against rights and deprivations of rights under color of law and color of law. It's these just laws that we got, and nobody tells you that in school. They just give you a packet of stuff to read, and you're supposed to know whatever that packet of stuff is, but they actually need to teach you with this stuff right here. Is that um, but I mean, you can look it up. I mean, just everything's legal. uh, but if you read it, its appearance of semblance without substance of legal right, misuse of power, possessed by virtue of state law, and made possible only because wrongdoer is clothed in authority of state, is action taken under color of law. Black's Law Dictionary, 5th edition, page 241. Um, it's right there. I mean, if you just look it up yourself, you can find all this information out. And it's what our forefathers put in place. Is that is it for situations like this? Is it you got the government, which is I'm calling the government my police and my sheriff's department at this point in time. But I did ask for help from other people's also, uh, but I'm fighting my little fight over here in Orange, Texas. But anyway, uh, but color of law is if two or more persons conspire to injure, oppress, threaten, or intimidate any persons in any state, territory, commonwealth, possessions, or districts in the free exercise of enjoyment for any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise on the highway or on the premise of another with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years, or both, if death results from the acts committed in violation of this section, or if such acts include kidnapping or attempted to kidnap, aggravated sexual abuse, or attempted to commit aggravated sexual abuse, or an attempted to kill, they shall be fined under this title or imprisoned for any term of years or for life or both, or may be sentenced to death. Now, I mean, you can't get no better than that right there. I mean, that's pretty much law. It's U.S. code, conspiracy against rights, and it's just that's the law. But uh, we haven't been taught the law because they hide it from us, and we depend on lawyers to look for us when we can do it ourselves. I mean, it just makes sense. But I had asked several um, uh, attorneys to help me and my journey to file a lawsuit against the people who've done me harm. Um, but I couldn't find no attorney to help me because I don't know why. I guess they didn't want to go against the beast. And I'm saying that the beast is the system, the courts, everything. I don't know, but I mean, you can't be scared all your life. I don't know. It just to me, it's a lot going on. What happened to me and my wife, and what's been going on for the past little over a year, with me and my injuries, are it's beyond belief. I mean, I just can't make. I don't understand it. The way the justice system is, the way these police officers feel the need to do what they do, and I mean, like I said, I'm not anti-cop. I feel we do need police officers, but you gotta know the law. If you don't know the law, you you kind of you're messing up the whole aspect. And if everybody in your little clique uh, uh, don't know the law, and or they just go with it, they're just as guilty as the other person. And this is what happened in my case: is that two officers violated my constitutions and ripped me out of my car and broke my arm and so on and so forth. But I mean, I'm not going to get into that right there. But I'm just going to state the fact that on June 12th, 2023, I filed my 1983 constitutional law lawsuit. That's the number. You need to look it up. Filed it. It's there. I'm not going to read upon it. If you're interested in doing that's your business. I mean, everything I say is true and correct. I'm suing 17 people. Um, right now, I'm not going to name them. Like I said, if you want to know them, I mean, I'm suing them all the way from the mayor all the way up to the people who broke my arm. So, I mean, you can find that out through my thing. I mean, everything I say is true and correct. And what gets me is I asked each person for help, and I was like just a piece of trash. I was just garbage, and it just blows my mind is that I was treated this way, and I hope nobody else goes, has to be treated this way, and and so on and so forth. But there's a lot of laws that they violated, a lot of constitutional civil rights that they violated. Um, they it's quite a bit that's going on. But also, I just like I said, the court date. I got a court date. I'll tell that later. Um, well, I can tell that now. It don't matter. My court date for the hearing is September 12th of this year. So the judge's going to say yay or nay. But I got a meeting with the mines August 3rd. I'm speaking with the attorneys, which I got I got their paperwork. I'm gonna kind of touch on it. I got their refusals or dismissals that they're sending to the judge, and reason why. I'll kind of touch on it, but yeah, I'm suing 17 people. They just, I mean, I don't know who else to turn to, but everything's according to law. Every statute I put in my lawsuit, it's statute law. It's man's law. So man kind of taught me law. I don't know if y'all anybody that's on here now or seen my stuff, live stuff, know that I speak the truth. And I did a crime back in '93, and I told the truth, and I was guilty of it, and they charged me in, but not the other guy. But it's all right. I did that. But anyway, this is City of Oranges. Oh, yeah, this is a good one. This is from John Kimbrough. He it's all public knowledge. He sent a letter to the court of the Eastern District, and saying Orange County defendants motion to dismiss. This is for the Sheriff's Department, Orange County Sheriff Jimmy Mooney, Orange County Sheriff, each sued in the individual and official capacity herein, and filed motion to dismiss pursuant to Rule 12, Federal Rules of Civil Procedures, and would respectfully show court as follows. Nature, stage, or proceedings. This matter arises generally from the arrest of Edward Lee Gonzalez on or about June 24, 2022, and including circumstances leading up to the arrest, medical care rendered immediately thereafter, and his various interactions with law enforcement officials in his complaints or requests for investigations about the arrest. Plaintiff filed their complaint for violations of civil rights on June 12, 2023. See Doc 1. Generally, although Michelle Renee Gonzalez is identified in the complaint as additional plaintiff, there are no factual assertions nor allegations that any defendant herein violated any right of hers nor caused any damages or injury to her. I'm not going to discuss that right now, but as for the county defendants, plaintiffs make only a vague and conclusory assertion that Orange County Sheriff violated Edward Gonzalez's First, 8th, 9th, and 14th Amendments under the Constitution. See Doc 1, page 15 of 21. Summary of argument. Plaintiff complaint fails to state any claim for relief, particularly as the county defendants, first plaintiff, has no federal. Okay, now this is a good one. Okay, plaintiff has no federal constitutional right to have an appointment with the county sheriff. Further, plaintiff official capacity claims should be dismissed as duplicate of any claim of the claims against the county. Finally, the plaintiffs failed to overcome the defense of qualified immunity with respect to any individual Orange County defendant. As a result, the court should dismiss plaintiff's complaint in its entirety and dismiss all claims against the Orange County defendants with prejudice. Factual background. On the evening of June 24, 2022, plaintiff Edward Gonzalez was arrested by officers of the City of Orange Police Department. Plaintiff alleges that he sustained a physical injury as a result of that arrest, for which he received medical treatment. Plaintiff later met with various law enforcement officials and other individuals in effort to obtain information, complaint about his arrest, and or secure one or more investigations into those involved. See Doc 1, page 17 through 18 of 2021. specifically as pertinent to the county defendants. Plaintiffs allege that August 9th, 2022, I went to make an appointment with the Orange County Sheriff's Department with the sheriff, Jimmy L. Mooney, but he never accepted or answered my request. See Doc 1, page 17 of 21. Sink in the entirety of plaintiff's complaint. This single sentence comprises the totality of the factual allegations against county defendants. Further, although the complaint elsewhere lists a number of constitutional amendments he asserts have been violated by Sheriff Mooney, Doc 1, page 15 of 21, the complaint makes no attempt to link the alleged violations to any specific act or omissions of the county defendant or otherwise articulate how the sheriff's failure to respond a request of the appointment violates any federal constitutional right. I don't know. I don't know. It's crazy that, I appreciate y'all. I'm just now seeing the thumbs up. Appreciate it. But it's crazy that these people just feel the right to do this. I mean, so they said they feel that the sheriff failed to respond a request for employment violates any constitutional rights. I don't know. I shouldn't. I think that's the First Amendment. But anyway, do y'all agree with that? Whoever's here, the First Amendment of the Constitution means that we have a right to redress our government officials of grievances. I mean, I could have sworn that's in there, but I could be wrong. So, yeah. And petition the government for redress of grievances. Yeah. So this is their issue before the court as a county defendants. There are three primary issues before the court in this motion. So this is their three primary courts. So y'all listen up. A, plaintiff has no federal constitutional right to receive a meeting upon demand with the Orange County Sheriff. I had to take a breath for that one, but I would love to be a fly on the wall whenever the federal judge read that one. The federal constitutional right type judge, if you read that one. But that's A. B, plaintiff's official capacity against Sheriff Mooney are duplicate of claims against the county, which they're duplicate against the city, but it's county, city, whichever. And C, plaintiff pleadings are inadequately pled and insufficient to overcome the defense of qualified immunity with respect to any individual Orange County defendant. Means that they feel that they have qualified immunity because I'm a Orange County defendant. I mean, I don't know. I mean, whenever you violate your 18 U.S. C 241, 242, you just lost that one. So and it's all right here in black and white where the person representing you just sent it. So so that was C. Arguments and authorities. The standard for dismissal under Rule 12b-6 is well established. All you can do is look it up. It's just Rule 12b-6, as well established to state a claim upon which relief may be granted. A plaintiff must plead sufficient facts such that a claim for relief is plausible on its face. Bell Atlantic Corp versus Twombly, TWOMBLY, 550 US 55544, comma 569, 2007. A claim has factually plausible when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Acrosoft versus I can't even see that. Say that. It says LQBAL 556 US 662 68 78 or 678 2009. A complaint that sets forth nothing more than naked assertions devoid of further factual element enhancements is insufficient to survive a motion to dismiss. Bell Antifor. So this is what they're saying. That's the third page. This is the fourth page. Plaintiff has no federal constitutional right to receive a meeting with the county sheriff or to compel an investigation. So this is what they're saying, is that they're saying that I have no federal constitutional civil right to have a meeting with my sheriff. I don't know if y'all see a problem with that, but I kind of do. I mean, we're all paying taxpayers. I mean, I don't pay much in taxes because I live small. You know, I don't live big, so I don't got that much taxes. But regardless of how much taxes I got, I still pay it. So I'm a taxpayer. So I deserve the protection and the civil rights as any other person's, including law enforcement. You know, I don't have that protection of immunity right now, and I'm trying to take that away from a lot of people, uh, from every law enforcement. That's my goal. Is just they shouldn't be better than me, and I shouldn't be better than them. That's facts, you know. So they, you know, be like, I don't know. It's just it shouldn't. It's not in the Constitution for them to have immunity. Period. Um, show me where it's at. It, you show me where it's at, and then we'll talk. But there's nothing in there that says that everybody that under law enforcement should have immunity from trial or tribulations of their actions. Everybody should be held accountable for their actions. And this is the things that I'm doing, is that I'm holding everybody accountable. Well, I'm holding most of the people accountable for what they've done. But anyway, plaintiffs' sole factual allegations against the county defendants is the assertions that the county sheriff failed to accept or answer plaintiff Edward Gonzalez's request for an appointment, Doc 1, page 17 of 21. However, as a private citizen, no, I'm not a private citizen. That's where they make the mistake. Plaintiff has no constitutional right to compel a meeting with the sheriff or any government official, nor does he have any right to compel the sheriff's department to conduct or assist in any specific internal or external investigation that's pertained to plaintiff. Meaning that I can't ask them to go look into somebody, like a law enforcement officer breaking somebody's arm or hurting somebody else. I don't have that constitutional civil right. I mean, I guess they're mightier than we are. I don't know. Are we the people? You know, I thought we was the people, and they was our employees. I don't know. It's just kind of weird. I appreciate everybody. I can't read all the comments, but I do appreciate everybody logging in and logging on. I love y'all. Appreciate y'all staying with me and seeing my fight. I'm just hoping that people could just learn and do what I do. Because I mean, you ought to see my evidence. It's just crazy. But I'm gonna share everything I got. I mean, it just blows my mind. It's so easy to do this if you're an honest person, or even if you're not honest and you broke the law. You have to know the law. You know. But anyway, I'm gonna get into it. Um, So, however, as a private citizen, plaintiff has no constitutional right to compel a meeting with the sheriff or any other governmental official, nor does he have any right to compel a sheriff's department to conduct or assist in any specific internal or external investigation as pertains. Roland versus City of Brownville, Texas, 182 F Appendix X 362, 364, Fifth Circuit, 2006. Nothing that a failure by law enforcement to investigate does not rise to 1983 liability. Gregor versus Jowers, 404 F3D 371 373-74, Fifth Circuit, 2005, holding that a plaintiff has no federal protected liberty interest in having his grievances resolved to his satisfactions of therefore. Any alleged due process violations arising from the alleged failure to investigate his grievances is indisputable meritless. Means that they're saying I ain't got a leg to stand on because they don't have to do what they do. Moreover, this is 11. Moreover, Section 1983 is only concerned with federal rights. Graham versus Connor, 490 U.S. 386, 393-84, 89. So these are case laws that they have that they're quoting. So I'm hoping they looked them up and just looked at my YouTube channel. Note in Section 1983 does not confer substantive rights, but merely provides a means to vindicate federal rights elsewhere conferred. Therefore, as plaintiffs have failed to articulate a single specific concausable federal recognized right that has been violated by any county defendant, they have failed to state a claim for relief as to said defendants. B, any claim against Sheriff Merritt. See, I mean, I thought it was Mooney, but they put Merritt. Any claim against Sheriff Merritt in his official capacity is duplicate of the claim against the county, and therefore is subject to dismissal. So our sheriff is Mooney. So, yeah. So our sheriff is Mooney, but they got Sheriff Merritt there. I don't know. So in this matter, plaintiff has sued both Orange County Sheriff's Department and Orange County Sheriff in his individual and official capacity. The Supreme Court has made clear that official capacity suits generally represents only another way of pleading an action against an entity of which an officer is an agent. Haffer versus Mello, 502 U.S. 221-25, 1991, quoting Kentucky versus Graham, 473 U.S. 159, 165, 1985. In such circumstances, dismissal of the redundant official capacity claims against the official is appropriate. Graham Hodge, 619 F, Appeals 39495, 395, Fifth Circuit, 2015, affirming dismissal of sheriff in its official capacity where county is also a defendant. I'm not a defendant. That's where they're mistaken. John versus Hewitt, 893 F SUPP, 2D 817 828 SD Texas 2012, same. 14, as there are no claims by plaintiffs against the sheriff that operate independently of the sheriff's department as an entity, plaintiffs' allegations against the sheriff in his official capacities are redundant and are subject to dismissal as a matter of law. Excuse me. Plaintiff's pleadings are inadequately pleaded and insufficiently to overcome the defense of qualified immunity with respect to any individual Orange County defendant. Means they're more than us. They're higher than us. Okay. Additionally, Sheriff Mooney is entitled to qualified immunity with respect to any claims against him in his individual capacity. Government officials performing discretionary functions are protected from civil liberty under the doctrine of qualified immunity if their conduct violates no clearly established statutory or constitutional rights. So, of which a reasonable person would have known. Yeah, I would have known that he violated constitutional rights, but I guess the district attorney don't know that. Burge versus Paul River ONTY 103 FAP 823 825, citing Harlow versus Fitzgerald 457 US 800 818 1982. The burden of proof, sufficient facts to overcome the defense of qualified immunity rests solely upon the plaintiffs. See Atterbury versus Nakona Gin Hospital 430 F3D 245 253 5th Circuit 2005. When a defense invokes qualified immunity, the burden is on the plaintiff to demonstrate how inapplicability of the defense. Plaintiffs have failed to overcome qualified immunity herein because, as discussed above, plaintiff has failed to state a single plausible claim for a violation of any federal statutory or constitutional right. Well, he wrote them down. He said what I said he did. But anyway, conclusion and prayer. Based on the foregoing of Orange County defendants, pray that the court dismisses plaintiff's claims with prejudice and grant any other relief to which they are justly entitled. I'm guessing they're wanting to get paid for filing this piece of paper. Certificate of service, hereby certified that the 11th day of July 2023, the true and correct copy of the foregoing has been served upon all known counsel for the record in accordance with the federal rules of civil proceedings under the federal e-file systems or by regular mail. Assistant County. Order granting motion to dismiss of county defendants. Order this date came before the motion to dismiss plaintiffs. Complaint filed Orange County Sheriff's Department, Jimmy Mooney, Orange County Sheriff, and their individual and official capacities haven't considered the motion. Any response or replies of the applicable law, the court finds that the motion is well taken and should be in all things granted accordingly. The court hereby orders that the complaint of the plaintiff one doc against defendants Orange County Sheriff's Department and Jimmy Mooney, Orange County Sheriff, in an individual and official capacity be the same is hereby dismissed with prejudice, and plaintiffs take nothing from said defendants. Yeah, this is what they're trying to say is that I don't have no standing. But this is Jimmy Kimbrough, our district attorney. That's who he is. But he says, I have no constitutional civil right to speak to my sheriff. How many people agreed with that? I'm sure the Ninth Circuit was able to help you. Stand tall, you're absolutely right. Have redress your employees. But if everyone in the county wanted meetings with the sheriff all the time, well, my particular case is whenever they the police department break your arm and they investigate themselves and they found no wrongdoing, but I'm not charged with nothing. So I didn't break my own arm, and that just makes sense to me. Is that, that's what they're there for? Is they're there to protect people that things that happen like me. But but I mean that's his job to have time for us. I mean, what else is he doing? I mean, I don't know what he does. Uh, I don't never see him. But anyway, read the 10th Circuit case. Okay, thank you for sending me cases. Look up California uh, okay, appreciate it. Yeah, I appreciate all y'all's comments. How y'all doing, everybody? Like I said, I just read the letter from the district attorney. I got a letter from these are all the police officers, uh, attorneys. I guess I got a couple of them or whatever. Um, they're they're doing the same thing as motion to dismiss plaintiff's complaint, Doc 1, certain City of Orange defendants, and also the Lisa Garza. Um, she's a person that's over the insurance company. I mean, I sued everybody. I didn't leave. Well, I left a lot of people out, but I should have added more. But I got the just cause. They're gonna hear me. But the thing is that said I asked everybody for help, and nobody cared until now. And this is what you're supposed to do as we the people, is that you have to stand up for your rights. And it just blows my mind. Is that, I mean, I contacted everybody. I mean, I got pictures with the governor. I spoke to him for like 5 minutes about my issue. I ain't heard nothing. You know, Governor Greg Abbott. I met him. But I mean, it just blows my mind. Is that, if cops can get away with this with me, just imagine what else they're getting away with everybody else. And I never realized it till it happened to me. If I can use my platform to take a stand and help people, just like me, do what I did and am doing, without the help of an attorney, because everybody can do this, what I'm doing. I mean, I didn't even graduate high school. So it just blows my mind is that I have to know the law better than the law knows the law. But right here's the second order. Uh, it's a pretty lengthy read. I don't know if y'all want to stick around and read that stuff. Uh, but it names all the officers that are involved in the suit, that the people that did what they did. Is there any particular part that y'all want me to read, or because it's pretty lengthy? Um, I don't know how many people's on or what have you. Uh, one or two people. I don't care. I mean, it just I just want to teach people and make them understand that I'm fighting for the Constitution. My rights are just as important as your rights, uh, and so on and so forth. But they want to dismiss all the complaints against me and what have you. It says plaintiff's factual allegations and defiances. This case arises at a Mercy Health Clinic staff accusing plaintiff of Edward of delaying a patient's care and distracting their attention from the patient with emergency uncontrollable bleeding. After which plaintiff was asked to leave. Upon plaintiff's return to check on the patient, police were summoned. Officer McDonald approached and asked how plaintiffs were doing and if they were having a problem. And when the plaintiffs said yes and that they were leaving, plaintiff Edwards sat back, locked his door on the passenger side, and Officer McDonald asked plaintiffs to produce their IDs in case of health, in case the health facility wanted to do a criminal trespass against them. I don't know if they know 3802 penal code. They probably need to read it up on it. So, and criminal trespass against them. And Michelle started getting her ID, and Edward said, "No, I'm good." And when asked to get out of the car, he refused to do so. Officer McDonald allegedly unlocked the doors from the driver's side. The passenger door flung open, and Edward was met with officers Grantham and McDonald, who physically removed um, physically removed, excuse me, um, him from his car and told him not to resist and to put his hands behind his back. An alleged plaintiff Edwards was injured in the process and handcuffed. See Doc 1, page 16 of 21. The defense is concerning these allegations are discussed below. When Edwards told them they broke his wrist and dislocated his elbow, Officer McDonald said he was calling an ambulance. ID. There is no factual, legal-based potential constitutional amendment violations nor state tort against Officer McDonald alleged here. Okay. Officer Lovelace arrived and asked McDonald to get if he got his turkey. And McDonald said yes. There is no factuality, legally based potential constitutional amendment violation or state tort against Officer Lovelace or McDonald alleged here. It says Captain Longlois arrived asking why plaintiff was arrested and why he was removed from his car, and McDonald or Grantham or both responded he was arrested for failure to ID and resisting arrest. After Captain Longlois and Officer McDonald talked with hospital staff and a charge of terroristic threat was alleged, added ID of 21, there is no factual, legal-based potential constitutional amendment violation or state tort against Captain Longlois alleged here. Captain Longlois told Grantham to bring plaintiff to the hospital because he refused my ambulance ride. Medical Center, Southeast Texas, Port Arthur, Texas, which, although allegedly 30 miles away, was the nearest hospital where he was x-rayed, examined, and released to the police department's care. There is no allegation of a delayed medical care injury. Arms broke, still broke. There's no factual, legal-based potential constitutional amendment violation or state tort against Captain Longlois or Grantham alleged here. The docs allegedly felt the injuries were the doctors allegedly felt the injuries were pre-existing, and the plaintiff claimed they lied, and Officer and Grantham and McDonald said they were unsure of any broken bones and needed a radiologist to confirm same. There is no factuality, legal-based potential constitutional amendment violation or state tort against officers Grantham or McDonald alleged here. It's crazy. July 11th, day 2022. 17 days after the incident, plaintiff went to the Orange County Police Department to receive his incident report and to talk to Detective Ward, and wanted to give a statement after receiving the report and talking to Detective Ward about what happened that day. He was told it was too late to give a statement because they had turned everything over to the district attorney. There is no factual, legal-based constitutional amendment violation or state tort against Ward alleged here. On On July 12, 2022, Detective Jinks called plaintiff and stated the district attorney had dropped all charges. Plaintiff then requested a body camera footage and video statements in his case, and Jinks said he would get everything ready for him. There's no factuality, legal-based, potential constitutional amendment violation, or state tort against Detective Jinks alleged here. July 18th, plaintiff talked to Captain Ashworth about charges complaints against the officers involved, and he directed plaintiff to Captain Longlois, whom dispatch contacted, and Longlois returned to the police station, and which time plaintiff spoke to him regarding the officers, and Captain Longlois told plaintiff to go online and file his complaint. There is no factuality, legal-based, potential constitutional amendment violation, or state tort against Captain Ashworth or Longlois alleged here. On July 26, 2022, plaintiff spoke to Major Sparky Robinson about his assault, and Major Robinson told plaintiff to talk to Major Wade Robinson. On Thursday, July 28, 2022, which they did to review the body camera footage and discuss what happened and file complaint charges against McDonald and Grantham, and plaintiff was given the complaint form. There is no factuality, legal-based, potential constitutional amendment violation, or state tort against Wade Robinson alleged here. On September 19, 2022, plaintiff spoke to City Manager Mike Kuntz regarding his complaint and to bring same to his attention, but alleged no help. There's no factuality, legal-based, potential constitutional amendment violation, or state tort against City Manager Kuntz alleged here. 15. September 21st, 2022, he spoke to Police Chief Martin and Major Robinson to get an answer on his complaint and find out other unspecific information, but alleged received no help. There's no factuality, legal-based, potential constitutional amendment, or state tort against Chief Martin or Major Robinson's alleged here. On September 27, 2011, yeah, that's what it says, 2011, he went to city meeting to speak with Mayor Spears and read Title USC 18, Title 18 USC Section 241, 242 on record. So I read this to him on record. So it's facts. There is no factuality, legal-based, potential constitutional amendment violation, or state tort against Mayor Spears alleged here. Yeah, anyway. So, 18, Lisa Garza, an adjuster for the city's risk pool, after an investigation, simply denied plaintiff's claim. They just simply denied it. Said that they investigated themselves and found no fault of their own. So she ain't paying me nothing. Says there is no factuality, legal-based, potential constitutional amendment violation, or state tort against Garza alleged here in either her individual or official capacity. So 19, plaintiff alleges he went to file charges on the two health care employees, but the detective ward did their investigations and did not file charges. There is no factuality, legal-based, potential constitutional amendment or violation, or state tort against Ward alleged here. Allegations recited in paragraph 1019 asserted plaintiff was allowed to file a complaint and perhaps sought to have some of the defendants charged and was not happy with the investigation results. I didn't break my own arm. Yeah, I'm not happy. However, plaintiff has no constitutional right to having his grievances resolved to his satisfaction. Okay. nor a right to have someone else investigate and criminally prosecute. Geiger versus Jowers, 404 F 3D 371 373-74 5 Circuit 2005 held plaintiff does not have a federal protected liberty and interest in having his grievances resolved to his satisfaction. Oliver versus Collins, 914 F 2D 5660 5th Circuit 1990. A plaintiff does not have a constitutional right to have someone criminally prosecuted. Okay. Leaf Burr versus Aquila, 15 F 4 4th 650 655 5th Circuit 2021 established proceedings requires us to conclude that plaintiff lacks standing to his sue defendant based upon his failure to prosecute or even investigate another. So I mean, did y'all do y'all's investigations? As described above in paragraph 2 with document 1, paragraph 2B on 13 of 21, plaintiff simply generally and inconclusively fashion list numerous alleged constitutional amendment violations and federal criminal and or Texas Penal Code violations, and there is no attempt there or elsewhere in the pleadings in section 3C or otherwise and link some factual to any acts or omissions by any of the defendants herein. See Doc 1 generally. Doc 1 paragraph 4 of page 20 of 21, plaintiff in addressing his injuries again simply generally and conclusively fashions list constitutional amendment violations, criminal violations, as well as numerous state law torts without factually specifically to which defendants they apply. Plaintiff also fails to plead any alleged city authorized policy or custom that was moving force behind any alleged constitutional violations. Generally, plaintiff defiance complaint is filled with conclusory allegations regarding alleged denials of various alleged constitutional rights, some of which are incorrectly stated or pled, or are not actionable, or some of which fail to factually describe how each defendant alleged violated plaintiff's constitutional rights or state or tort law, or all of which fail to overcome each individual defendant's qualified or governmental immunity from suit. The applicable law and pleading defiances are further described below. Statement of issues to be ruled upon. Plaintiff claims against the City of Orange and their official capacity claims against city defendants Longlois, McDonald, Jinks, Robinson, Grantham, Lovelace, Ward, Ashworth, Martin, Spears, Kuntz should be dismissed as official capacity claims are duplicate of the claims against the city, and plaintiff has not pled a policy or a custom of the city which was the moving force behind the alleged constitutional violation. Plaintiffs presume attempted 42 USC 1983 unreasonable seizures claims under the Fourth Amendment against defendant, if any, should be dismissed to the extent plaintiff failed to plead a seizure of defendant or the facts indicating reasonable suspicion of defendant, reasonable suspicion to detain plaintiff was lacking, or fails to plead facts indicating probable cause to arrest plaintiff was lacking. Three, plaintiffs presume attempted 42 USC 1983 excessive force claim under the Fourth amendment against defendants, if any, should be dismissed to the extent there is no factual plead, objectively unreasonable, unnecessary use of force by defendants. Plaintiff's state law tort claims against the city are barred by government immunity. So they got government immunity. Plaintiff's state tort law claims against the defendant, city employees, and official must be dismissed under Texas Civil Practice and Remedies Code 101.106E. 6. Plaintiff's 14th Amendment claims against the defendant, if any, should be dismissed as plaintiff fails to factually plead any such claim or which would violate the 14th Amendment. Plaintiff fails to factually specify a claim under the First, Second, Fifth, or Ninth Amendment of 18 U.S.C. 241, 242 against defendants, if any, and the same should be dismissed. Plaintiff's U.S.C. 1983 claims against the individual defendant based upon factual unspecified violations of the Constitution should be dismissed as plaintiff has not factually pleaded said claims in any such ways that they overcome the qualified immunity of individual defendants. So motion to dismiss. They're just saying that I didn't raise a factual possibility when the plaintiff pleads factual content that allows court to draw reasonable inference that the defendant is liable for misconduct alleged. I mean, all we gotta do is look at the body camera footage. I mean, it's right there. But that's their saying that their standards and their argument. I mean, like I said, it's a lot to read. I'm pretty much out of breath. I'm in so much pain right now. But it's already been, how long has it been? Almost an hour. I appreciate whoever's been on. I appreciate all the information. But yeah, they're trying, but like I said, they filed all this paperwork. This is 33 pages. 33 pages of motion to dismiss and plaintiff. So this is a whole city of Orange. This is their stuff. This was the sheriff's department stuff. I haven't heard anything from the doctors, lawyers. I'm gonna try to contact these two attorneys tomorrow and see if they know who the doctor is and so on and so forth. That way we can get them. They were served also. So the two doctors. But this is my you ever see it or not? This is my answer, and these are all the people's, and that right there, that's my dates. So that's when I'm going to. I got a meeting with the mines August 3rd. I might come back on and give you an update on that one. August 3rd, I got a meeting with the lawyers. Like I said, I'm gonna try to find out who's the doctor's attorneys, maybe tomorrow, and go from there. And then it says I gotta have an answer on or before August 11th. So August 3rd, they'll have their answer by me, and whatever the lawyer is going to have their answer. But they got to have it within, before the 11th. But they'll have mine on the 3rd. And then it says number 2, complete initial mandatory disclosures required by this order, meaning that I got to have all my evidence and turned in, I guess, to the county clerk. uh, 10 days after the meeting. So, and I'm gonna have mine turned in same day. Uh, and it says right here, file joint report of attorney conference is due on before September 1st. Meaning I got to have my letter saying yay or nay. So, and then it says the case is set for a ruling 16 case management conference on September 12th, 2023 at 10:30 in courtroom 4. So it's gonna be a good day, I believe. But I do appreciate y'all's time, and I just seen somebody else. I appreciate what if we just woke up every day, want to do better than the day before. If we make a mistake, we change our ways. But too many proud men. Hello, how's it going? Wish you well. Appreciate it, everybody. I, it's all in God's time, and that's all I got to say. Is that I mean, it just amazes me is that I have to hold these people accountable for the fact that they broke the law. I mean, I broke the law in 1993, and I admit to my guilt. I did it, and the guy who did it, who brought me to the house, did it also, but he didn't get charged. But like I said, I'm it's okay. It's everything's happened for a reason, um, and it made me who I am today, a better person, and my trials and tribulations. And I'm hoping that other people can learn of what my mistakes happen, and hopefully they can overcome their addictions or their lawsuits. Um, but it just amazes me is that I didn't want to go there. I didn't want to do this, but I mean, how else am I going to get my arm fixed? My arm is still. A lot of people ask me what's you know I don't know if you can see it or not. It's kind of hard to tell, but my ligaments are torn off this bone here, and it's torn off here, and it's torn off here. Um, that's a ligament sticking out. Uh, this is my good elbow. Um, I don't know if y'all can really see that one, but that's a good elbow right there. That was a motorcycle wreck I did in 1998. Yeah, or excuse me, 1988, 87 to 88. Yeah, and I slid 210 feet on that elbow, but this was my good one, but now it's not my good one. I don't know if you can see the roundness. You see the bones right here. Look, don't not that one. Look at the bones right here. It's round. That bone is no longer round because they tore the ligaments off this way and this way. So they're both torn off that one, and like I said, it's torn there. Um, my back muscles are torn. My rotary cups, both my rotary cups are torn. Whenever you get jerked out, if y'all seen the video, they jerked me on my right arm. They both had my right arm. They jerked me out. It says in their police report that they both had my right arm, and they messed my rotary cup on this side and pulled my back muscles out. But I'm in a lot of pain. Uh, I have one of them faces that doesn't show pain because I've been through so much. It don't make no sense. Um, but I'm just going to hold everybody accountable. I mean, I'm fighting for the Constitution. Um, how much is it worth? Uh, to me, it's worth my life. I'm suing 17 people, so I appreciate it, Law G. But I mean, it it is what it is. But everybody's got to hold them accountable. If I broke an officer's arm, what would happen to me? I'd be under the jail, you know. So I just don't see how they can have qualified immunity if they hurt somebody, and it's okay. It's not okay. But we're going to see. But I do appreciate everybody coming on and just watching my videos. I'm hoping it'll help somebody and hold people accountable. I mean, you gotta do it yourself. Can't depend on somebody else to do it for you. Uh, you know, I mean, they want us to obey laws, but they don't want to obey them themselves. But it's okay. We're gonna see them in federal court. Um, but I took enough of y'all's time. I appreciate y'all's time, and uh, y'all have a blessed day and blessed night. Uh, God's coming back. The Constitution's coming back. Um, I'm fighting. I'm fighting for their for the Constitution. I mean that's what I'm fighting for. Their supply chain worth 30,000 Walmarts. I don't understand. Um, yeah, I'm trying to figure that one out. Uh, I don't know if he's on the right one, but hey, I do appreciate everybody. The Resistance channel. He's the one that helped me get started. To kind of show me, what he did, and then that's what I did. I started my own channel, but and then uh, Blue Line Whistleblower. Uh, he helped me tremendously get my channel up there. I do appreciate it, everybody. Um, there's a 1813 News. He's a local news people, but I guess he's scared or something. I had I had talked to him, but he don't want to talk to me apparently. But he put my stuff out there. I want to give him a shout out. Appreciate it. But you can't be scared of the beast. They can't eat you. If they do, hopefully you'll be dead. But anyway, city officials detailed vehicle purchasing difficulty due to supply chain inflation. What the heck is that? Oh, this guy's probably lost. Um, but anyway, I don't want to take any more of y'all's time. It's a pretty long video, but that's an update. I got a court date is September 12th, the day after 9/11. Um, I want to give thanks to my God, Jesus Christ, Lord and Savior. Um, everything without Him, it's nothing. So I'm gonna go ahead and get out of here. God bless. Take care.